Welcome to Small Business, Big Legal Concerns. I am Bridget Lake with the Oviedo Winter Springs Regional Chamber of Commerce. We have a few chamber announcements. We have events Monday, July 27th, the Virtual Business Alliance. Tuesday, July 28th at 4 p.m., we have the Digital Marketing Workshop from Valconics talking about Pinterest. On Wednesday, July 29th at 4 p.m., we have the Real Estate Connection. On Thursday, August 2nd at noon, we have Small Business Success with Jesse Wolf. If you're interested in sponsoring any of our Zoom meetings, it is only $100, and you can contact business@ovidowintersprings.org. Now, we want to recognize all of our trustees at the Oviedo Winter Springs Regional Chamber of Commerce. And as for today's sponsor, we have School of Rock. School of Rock is the worldwide leader in performance-based music education. They teach guitar, bass, drums, guitar, and vocals. They are proud to know that their great community of student musicians has made a difference to so many during these difficult times. They are also excited to begin the process of returning to in-person instruction safely. And now today I would like to introduce Ronnie Bitman, is the co-founder of Bitman O'Brien Morat, and is considered one of Florida's leading lawyers. Aside from handling day-to-day firm operations, he has litigated a wide range of complex and unique matters, which gained him recognition as one of Florida's Trends Rising Stars, Florida Trends Legal Elite, and Florida Super Lawyers. Now, Ronnie has handled an array of complex commercial matters ranging from consumer fraud class actions, contract and employment disputes, trade secret litigation, unfair and deceptive trade practice matters, intellectual property litigation, business and partnership disputes, personal injury actions, wrongful death actions, numerous appeals, and multiple business transactions. Ronnie is general counsel to several major business clients, handling many aspects of overall business strategy, litigation prevention, transactions, litigation, and appeals. Ronnie, thank you so much for joining us today. How are you doing?
Good. Thanks for having me.
Of course. Now, before we get into your program today, I have to ask you this. You've got some really awesome electric guitars behind you. So I have to ask, do you play them? Do you collect them? Tell us the story about those.
So in my high school and college days, I was a punk rocker. So that's kind of a vestige from that. Now it's more decoration and just to remind my kids that they need to take up an instrument. And probably after this, I'll have to give School of Rock a call, get back into it.
What band, what was your band's name?
Well, I just played with some friends, but I grew up in Los Angeles and in the 90s when, bands were coming in and out of Hollywood, like No Doubt, and Green Day was coming through there. And those were the kind of shows that we used to go to.
I love it. Bringing back memories right now. So let us start with your presentation when you are ready.
Sure. So I, through this chamber, obviously, we have a limited amount of time, and I wanted to get through various topics that are timely to give everyone kind of a brief overview of current events that are affecting businesses, affecting employees in light of the COVID pandemic. This is not meant to be great detail. Everything with the law is always very fact-based. everybody's specific situation, every circumstance is unique, and all facts have to be flushed out before getting any opinion or having the situation apply to your specific factual situation. But this is just meant to be a high level insight into things going on. If you own a business, if you're an employee, things to look out for, and in things that are happening, which are kind of unique into today's world. So with that, let me
I love this
presentation
topic
started.
too. And while you're transitioning to your slides, I absolutely love this topic because it's so current and important. And I know that, as I was saying, the chat box for everyone, make sure that you type in your questions, because I know that a lot of our businesses during this time will have questions regarding this. I know that I have questions. A lot of businesses will have these questions. And now is a great opportunity to get the clear advice on this topic. So thank you, Ronnie, so much for joining us today.
Yeah, and you're able to see my screen?
Yes, perfect.
All right, so here's my contact information. Again, I'm a managing partner of Bitman O'Brien Morat. My email address, if anybody has any questions after this, is rbitman, R-B-I-T-M-A-N, at bitman-law.com. And then our social channels are at Bitman Law Firm. And what I'm going to discuss today is basically 4 broad topics. Each of them, you could do an hour on each of them, but we're going to race through and give you some high-level information on basically 4 broad topics. The first is returning to normalcy, and we're going to discuss how do you do that and what does that look like. The next topic is contracts in the age of COVID, and basically what the issue there is can you cancel contracts, or can somebody cancel contracts that are already formed on you because of the pandemic, or can you get out of contracts that you've already signed, leases or contracts for supplying product or purchasing product. The other thing we're going to discuss is cancel culture. Cancel culture, I think, has become a lot more prominent with people not having sports to watch, and all they're doing is trying to work from home and using social media. And there's a lot of time to sit and get angry about people's opinions. So we're seeing a lot about that. And then the 4th topic is general employment issues, how you're dealing with employment issues, either working from home or just in general, even if your business is still open. So returning to normalcy, I have a quote here from Benjamin Franklin, which says, "By failing to prepare, you are preparing to fail." And I kind of used that quote or philosophy for anything that I do, but with respect to getting back to normal or operating during the time of the pandemic, prepare, prepare, prepare. That's really what's going to help assist and guide us all at this time. So preparation is key. The question really is different for people who have, for instance, brick and mortar stores, or people who have employees who are working from home. This is geared towards those people who have a location, or they have employees coming to an office, or they have customers coming to an office. And the question, the overall question really is, hey, can I get in trouble? Can I run afoul in some legal capacity if I open my store, if I open my business? How are customers going to be affected? And secondarily, how are employees going to be affected? And can you sue, or can you get sued for opening up your business and letting employees in, letting customers in? And there's a lot of unknowns. We haven't had a pandemic, global pandemic, or a national situation like this for over 100 years. So laws, court decisions are not entirely clear on what the issues, what the outcomes on these issues are going to be. But these are things that we need to address and need to deal with. And even if there are not specific answers, I always default back to the rule of reasonableness. What's reasonable? Now, the question is, what do we do? How do we let people back into the office? How do we let customers back into our stores? And there is no answer. The best thing that you can do, again, is to plan and prepare, use online resources. If you're able to provide masks for your employees or for patrons, do so. Hand sanitizer, and enforce distancing. You're walking into restaurants and you see little X's on the floor about where patrons are standing. That's them doing their best to enforce distancing as the government is instructing. And the other thing is whether or not to obtain liability waivers. So there's really a question as to whether or not, if you open your shop, your store, whatever it is, and somebody gets sick, can they sue you? The short answer is yes, they can. Whether they win or not is going to be a different analysis, a different question. It's very hard to win those types of cases, but yes, they can sue you if they get sick at your store. That's not only customers, but also employees. Now, the analysis is a little different with employees because the state requires employers to have workers' compensation. So the likelihood is, if you have employees coming to work, coming to your office, and they sue you, in all likelihood, workers' compensation is going to cover that issue. There's a question as to whether or not that's the case or not. It hasn't been fully flushed out yet, but typically employees would probably be covered by workers' compensation. It's a little different with respect to patrons. It's very hard for somebody to prove that they got sick on your premises as opposed to on the way to your premises. But a lawsuit against you and you having to defend can be devastating, especially if you're a small business. So there's certain things that you can do to either prevent or minimize such suits or frivolous suits, or even if the suits are viable. And some of those things are complying with government recommendations, putting plexiglass between, if you go to a supermarket like a Publix, a lot of the, or Target, they have plexiglass between the cashiers and the patrons. They have the marks on the floor, people are wearing masks, sanitizers available, those types of things. So if you do the...
Ronnie, let me ask you, and forgive me for interrupting, but I have a question myself, because I
Sure.
deal with a lot of small businesses. And a lot of them are just curious, following all the protocol that you've spoken about, making sure that, they require their customers to wear masks. They're, following the social distancing, putting their signs up, making sure that it's noticeable, that they are doing everything that they can. I don't believe that some of them are not having people sign waivers, like every customer signing waivers as they come in. I don't know if everyone's going that far. I think that really depends on who's coming in and who isn't, and what business it is. But what are the policies, or how does that work? Has there been a lot of suits going out? Do you know about that?
So
Is there other ways to get protected, or how, how is this working?
Right. So it's all the way it's working is it's kind of a work in progress. We're learning things that are new every day. You asked, have there been suits filed about these things? Yeah, there have. From the information that I've seen, there's been, I don't know, dozens of suits throughout the country on these types of issues. And the question is, what can you do? And
how
what
can anyone prove it?
That's the hard part. The hard part is proving it. Now, there's some places, like there were meat processing plants and things like that, where dozens and dozens and dozens of employees got sick at the same time. I think it's easier to prove that it came from the work premises in a situation like that, as opposed to if you're a salon and someone came in for half an hour and they got sick, and they blame it on your salon. It's very, very difficult to prove that. Now, it's going to take a lawyer who is really, really confident in bringing that kind of case in, trying to establish that it came from your premises. That's very hard, if not impossible to prove. Now, when you go to court, you hear about our justice system. It's the greatest in the world, but it's very flawed. When you go to court, ultimately the arbiter of deciding whether or not you're wrong are 6 random people sitting in a jury. And all they have to do is find that it is more likely than not that it happened. So you're talking 50.1% in one direction versus the other, and those people can hold you accountable, hold you liable. So that's why you need to prepare. You need to have these policies in place. You need to abide by those policies. And if you do, you have that much better a shot of getting out of it. For instance, if you had no policy whatsoever and 1 or 2 people filed suit against your business and said that they got sick in your premises, and you have nothing in writing, you have no policy that you're complying with, it obviously is a lot easier for the plaintiff than if you said, look, we provide masks, we required you to wear a mask, we provided sanitizer, we required distancing, we have plexiglass, you've signed this waiver. If you do all those types of things, you're protecting yourself as much as possible, as much as you can. So that's why I think that the quote that I showed at the outset is really apt here, because there is no formula, there is no fail safe, there is no 100% inoculation from someone saying that they got sick on your premises. Now, what I will say is the federal government in Washington is working to try to provide blanket immunity to businesses.
Right.
And what blanket immunity would do, and what they're talking about, is making it retroactive till something like November, December of 2019. So what they're trying to do at the federal government level, where nothing seems to work and nobody seems to agree right now, is try to come up with a law that immunizes all businesses as an incentive for people to open businesses and work and have patrons come in. And they're working on that now. Whether that comes to fruition or not, that's the ways of Washington, and we'll have to see what happens. But they're talking about putting that in the next stimulus bill. And there is a lot of, one side of the coin says this will be fantastic and help the economy. The other side, mostly plaintiff lawyers or the trial lawyers bar, say, no, you shouldn't be providing businesses immunity, and people should be able to sue if they get sick.
Now, as far as employees, you hear about certain businesses around here who, luckily I haven't heard of anyone not saying, hey, listen, I think I'm not feeling well, or I have some symptoms. Maybe I need to go get checked, and maybe I need to just hold off on coming into work for a while. What if people aren't saying that and they're just going into work and not really saying anything?
Yeah, I mean, they're going to be spreaders. They're going to get people sick, and employers should kind of constantly check and tell their employees if they're not feeling good, don't come home, don't go to work, stay home, provide the ability to work remotely if possible. And that's really it. I mean, there's only so much you can do. You can go around and take everybody's temperature at the office, but then you get into all these privacy issues and a lot of things that are not fully developed yet as to whether or not you can do those things. But
yeah,
communication is key. Tell people that if they're not feeling well, if they were in contact with anybody, to stay away for a couple weeks, and follow doctor's orders and see what the CDC is saying and follow those guidelines. Review local, state, and federal government resources, see what they're saying. Here on this slide, it's a basic plan, but it's a plan. Provide masks and sanitizers, make sure that employees are distanced, disinfect desks and phones and things like that every so often. What you can do is alternate days and shifts. If you've got several people who are working in close contact, maybe have half come Monday, Wednesday, Friday, half come Tuesday, Thursday, and Saturday. And so just the best thing to do is have some kind of policy, make it a written policy, and stick to it until this is over.
Yeah.
And having such a policy will be better than not having it. And again, the hope is, as a business owner, that the federal government could come and provide the blanket immunity. That'll help a lot, and it will alleviate all these issues. But you can see on the flip side, that can kind of make people relaxed and lackadaisical about enforcing their policies, because if they have blanket immunity, all right, I'm going to save money. I'm not providing anybody masks. I'm not providing sanitizer, and you can't sue me. So that's the tug of war that's going on right now. Mm-hmm. Let's talk about liability waivers. What are liability waivers? Just like going to a baseball game, on the back of the ticket, there's liability waivers there. If you go into an amusement park, you are, approving or assenting to take on the known risk of participating in an event. This is kind of strange. This is kind of weird, because you're not doing anything here. You're going to work, or you're going to get a haircut, or you're going to get your nails done, and someone's providing you with a liability waiver. I haven't seen that myself happen too much, but I've had clients request them. I've read anecdotal news stories about people mandating liability waivers for patrons. Some of the universities with their athletes are making them sign liability waivers for participating in sports. And it's, in Florida, these liability waivers are valid and enforceable if both parties sign them, and, you can disclaim your own negligence, or you can agree not to sue somebody who is negligent. And, if you're very much a belt and suspenders type operation that wants to avoid liability, these liability waivers are something I would encourage. Now, if it's going to affect your business, or if people don't want to sign it, that's something else. That's something that each individual business has to determine on their own. But if I had, or if I was advising somebody who had a volume of people coming in, there's no reason not to, if it's not going to hurt your business, to have a lawyer draft a small liability waiver that says, hey, I know that there's a risk of coming in here and I might get sick, and it acts as, what I always tell people is, there's the law and then there's the law of practicality. The law is unknown whether these waivers are going to be upheld or not in Florida. But the law of practicality is that this would act as a disincentive for somebody to sue.
At least there's something. Let me ask you this question from the audience. What should be our procedure when someone from an employee's household is exposed? Example, Mr. A works for me. Mrs. A works at a dental office who had a hygienist test positive. Does Mr. A need to quarantine? Or do we need Mrs. A to be positive before quarantine? Assume nobody has symptoms.
Yeah, so I didn't go to, in law school, I didn't go to the medical school version classes. So that's more of a doctor related question. And that deals with transmission and what's the likelihood of the transmission and all those kinds of things. I revert back to the rule of reasonableness. Do you think it's going to affect you? Do you think it's going to affect your employees? And if it does, it's going to be a lot worse than if you take the precautions at the outset. So you've got to talk to them. You got to talk to them about what they think their exposure is, maybe take a couple days and see what happens. But it's going to depend on the circumstances. Frankly, I think in that situation where nobody's showing anything and it's kind of one or two people removed, me personally at our law firm, I would kind of leave it up to the discretion of the employee as far as what they think, and probably advise the other employees about it and see how they feel and make it optional coming in or not. Now, some places can't work remotely. Some places you have to be live and in person, and you're going to have to make that judgment call. It's always better to be safe than sorry. Now, again, that's more of a medical type issue. On the legal front, can you be sued because you knew that somebody twice removed was sick, but you allowed that person to come into the office? You could be sued for anything. It's going to be hard for that plaintiff to prove that it was your fault or there was a causation between your decision and somebody getting sick. So on something like that, again, revert to the rule of reasonableness. How distant do you think it is? What's the likelihood of there being a problem? Are there a lot of people very close to one another in your office or in your location? Separate, wear masks, use sanitizers, those kinds of things. But unfortunately, all of us are going to have to make those types of critical analysis decisions kind of on a daily basis, whether to send kids back to school, whether to go to a medical appointment, whether to go to the grocery store. You're going to have to make those kind of decisions.
Oh, I like this example right here.
This liability waiver?
Mm-hmm.
Yeah, so this is like a sample liability waiver that specifically deals with COVID and provides you with, as good of a stop block mechanism that if somebody sued you, you say, hey, look, you signed this, you knew that there were risks. The oddity here is it's not like you're going on a roller coaster, or it's not like you're going to a game where you might be hit by a baseball. There is relatively low assumption of risk going to the supermarket or going to a hair salon or to go buy something. Usually you don't have liability waivers for those types of things where there's very little to no risk involved. So this is, it's a different world for people when you're dealing with a pandemic that you can't see. You don't know where it is, and it could be everywhere. So whether these will be upheld or not is left to be seen. But if you have the ability, if you can, why not? So that's really it on the liability waivers and things to expect with respect to going back to work or dealing with, again, employees as workers' comp, but if you're dealing with patrons or people coming into your location, and happy to take any other questions on that front.
I think we covered a lot with questions. I know I asked a few that was from the audience, and is we moving on to the next topic?
Yeah, so let's talk about contracts in the age of COVID. one of the first things that everybody was trying to scramble and figure out was, what goes on? Do I have to buy what I was previously purchasing? Do I have to commit to what I previously committed to? Do I have to pay my lease? Not only residential, but if I have a commercial location and employees, and I can't go there because there's a government shutdown. The government is telling us we can't go. We're non-essential. We can't go to the office. Do I have to pay my lease? And that body of law in contracts is called force majeure, the fancy French name for it. And this body of law has been around forever, and it covers things that are beyond anybody's reasonable control. The definition of force majeure is a contractual provision allocating the risk of loss if performance becomes impossible or impractical or frustrated, especially as a result of an event or effect that the parties could not have controlled. And in Florida, the courts narrowly construe those provisions. They come up a lot in the construction context because of delays, weather delays, hurricanes, things like that. But you want to have force majeure language in your contract. And if you're trying to get out of a contract, you want to look to see if there is a force majeure provision in your agreement. It might be called force majeure. It might be called delay. It might be called excuse. There might not be a title for it, but the language in your agreement may or may not cover the situation. Now, courts narrowly construe it. Courts don't like undoing contracts. Contracts between private parties tend to be enforced under the terms, under the clear language of what's in the agreements. And courts typically want those contracts to continue unless it is clearly an event that was addressed in the writing and the parties specifically intended to address that situation in the agreement. And generally only will a court excuse the performance of a contract or agree that non-performance is okay if the event causing the non-performance is specifically referenced in the force majeure provision. So I'm going to show you here. A lot of times you'll see this in contracts as excusing performance because of acts of God. I mean, that's kind of the term of art that's used in a lot of contract is performance can be excused because of acts of God, something that is unavoidable through reasonable prudence, not fault of either party. Obviously, if a party does something intentionally to cause performance to be impossible, impractical, frustrated, those kinds of things, courts won't allow somebody to do that. But if something is truly beyond reasonable control, for instance, if you have a contract to finish building a home in a certain amount of days, but you have a force majeure provision that excuses acts of God, and a hurricane comes through and delays things by a month. Typically, courts will say that was covered by the force majeure provision. It's an act of God. Nobody could have controlled it. It's foreseeable. I mean, living in Florida, it's foreseeable that there would be hurricanes, but if it came in and affected you and in your agreement you had that carve out for an act of God, courts will say that your performance was excused. Something really interesting with respect to COVID is kind of two points on a force majeure. Not only is performance frustrated here because of the pandemic or people being scared or people not wanting to work or fulfill the obligations of a contract, but we also have a situation where the government has imposed restrictions. For instance, if you're not essential, you can't work, or curfews. Now, is that considered government action that has frustrated the purpose of a particular contract? Yeah. We don't have any decisions yet on particular force majeure language as related to COVID, but I can assure you that I, in many, many cases, am putting in COVID as a defense to lawsuits, not only as something that's covered by generic force majeure language, but also a lot of force majeure language says that if you're prevented from performing because of government action, and sometimes it's typically just as vague as that, as government action. I mean, if the government prevents you from working, does that count? I would say yes. The long and short is we don't have any appellate guidance yet on that, but those, over the next again, it's not going to help anybody today, but that law is going to develop over the next 6 to 8 months. And I can assure you, dozens and dozens, if not hundreds of cases that are going to be coming down the pike where commercial landlords are going to be suing for eviction or default, and the defense is going to be force majeure. Hey, I was prevented from operating. The government prevented me from using the facilities, or I can't purchase the 6 tons of oranges.
There have got to be a million. I don't know how people are not typing in the chat box like crazy right now, because I could ask you probably 200 questions specifically about my events right now.
Weddings. And
specifically about, we have Winter Springs Festival of the Arts coming up October 17th and 18th. So we're getting a lot. Thank you so much for this example. I love when you do that. We have so many things coming up of questions like, well, and we fully plan on having this event. We are full force ahead. And we're getting the questions of, well, what if you don't have it? What if this? And so there's so much going into what precautions we're taking, what we're doing with this, and what permitting, and we're working with the city and the county. But the language that we need to use in certain things, what contracts we're setting up, and there's so much. We need help with this. We need help with some language that we need to put into contracts, right, regarding the vendors that we use and also the vendors that are coming into the event, plus this, like all of this. So
yeah, absolutely. So here, I gave you a sample of a force majeure provision that is really extensive. You can see it. It talks about hostilities, invasions, military blockades, mobilization, civil war, riots. Now, I've bolded the part that actually applies to now, talking about plagues, epidemics, pandemic, disease, quarantine. That stuff wasn't in there as of 3 months ago. You had to be, you really had to be a lawyer that kind of foresaw everything to put that in a force majeure provision in a contract. Now it's going to be commonplace going forward forever. Mm-hmm. But if you see here, this is a very broad force majeure language. Like I said at the outset of this topic, the courts want to see the parties having addressed the specific issue and be as clear as possible. If you don't have this bolded language in here, would this provision apply to being able to cancel a contract for frustration based on the pandemic? I don't know. I mean, there's something here that says compliance with any law or government order.
I'm with you on this. I think that all of that language is important. I think we should add lightning strike to that also.
If it's not there, it might be. Violent storms, cyclones, hurricanes, destruction by lightning.
Oh, there we go. It is.
So I tried to pull a very, very broad one. But now, one of the questions, one of the cases that I reviewed prior to dealing with this was a force majeure provision dealing with the 2002 Olympics right after 9/11. the September 2011 terrorist attacks were followed by, I think it was February 2002 that the Olympics were in Salt Lake City.
Mm-hmm.
In one of the cases that I reviewed, the question was whether or not the force majeure provision, permitted an excuse of events related to the Olympic Games, and the language in the contract spoke about the force majeure event being anything that, quote, affects the ability of the Olympic Games to be held. And what the court said was there's a real question about what that provision provides. It is a minimal effect on the games what the parties intended to contract around, or did, quote unquote, effect of the games mean that the games in total could not be held? So even having a provision that says that these things are excused, you're not going to be able to foresee everything, but you got to be as clear as you possibly can. And even this provision right here doesn't really say whether or not you would be excused if these things happen, or whether they slightly affect your business, or whether they're totally catastrophic and prevent you from performing in total. So you got to get crafty with the language.
Let me ask, what are your clients telling you about today's business environment and how it's affecting the way they operate their organizations?
It's a tough question because people are doing what they can and operating how they can. I've not seen this come up really with respect to canceling deals or stopping purchase and sale, things like that. A lot of it's coming up in the lease rental context. And, the good landlords with really good and crafty lawyers, I've seen a couple provisions where there's this nice, broad force majeure language where you think you're going to be able to get out of it. And then the last sentence of it says, despite the foregoing, paying rent is not anything that would fall under the force majeure events. So you would still have to pay rent. Mm-hmm. Now, again, it hasn't been litigated. It has not, there's no appellate decisions on it. It kind of depends what a judge in an appellate court is going to say. I think that if you have a sentence in there that says that these provisions exclude the payment of rent and you have to pay rent, a court's going to say, well, you bargained for it. It's in there. It's clear. You have to pay rent even if you're not using it. Wow. Not having money or the government telling you not to work is not an excuse to not pay rent based on that language. Now, if you didn't have that language in there, I would urge everybody to look at their commercial leases and see what it says, because you may be justified in or have an excuse for not performing for the duration of whatever the event is.
Now, do you expect these changes to be a temporary thing, or until we see a COVID vaccine, or even longer through, I mean, who knows, 2021, 2022? I mean, I know you can't predict the future. I know you're not like a fortune teller here. Just kind of getting your forethought on this.
So this is going to affect anything that going forward, whether it is boilerplate language that's going to be in contracts, whether it's going to be how you're doing business. I just think that we're in the middle of it now, but I just think it was such a devastating impact that it's going to affect everything going forward. And surely lawyers, boilerplate, litigation, all of that is going to be affected. So you can bet any landlord who did not have the language in there that says you still have to pay rent despite all of this force majeure stuff, they're going to put that in there. So yeah, everybody's looking at everything right now.
Of course.
Yeah.
Well, thank you. I think that's really great information. I really do appreciate your examples also.
Sure. So I don't know if there's any chat questions or anything like that.
Not, they did like the lightning, and there was a couple little comments because of that, because I got struck indirectly by lightning about a couple of weeks ago. So
oh, wow.
is that interesting comment. So
Yeah.
All right, we'll move on to the next topic.
The next topic is cancel culture. This, like I said at the outset, I think that this is becoming more and more of an issue. Number one, because of the political climate. Number two, because of the virus and everybody being locked up and glued to social media. And like I said, not having sports to watch or maybe new shows and entertainment, not going to the movies. People are looking at social media and looking at brands online and looking at advertisements and things like that. And I think that it kind of fostered the environment that we're in now where we're dealing with this. And I'm seeing it on the legal front more and more, weekly, really. So what is cancel culture? Cancel culture refers to the practice of withdrawing support or canceling people and companies after they've done or said something that's considered objectionable or offensive. It generally arises in social media, and those that employ the practice in large groups are referred to as the mob. And this can come up in Instagram comments, Twitter comments, Facebook posts, Google reviews. And
do you think it's because a lot more people are unemployed and they have more time to do this?
I just think everybody has a lot more time on their hands. And, when you're shuffling kids back and forth to soccer or you're at work all day, there's a lot less time than to sit and look at social media or ads or, engage, comment, and that kind of thing. So yeah, I definitely think that there's not, mind you, we've been in a environment that's been kind of politically hot over several years. So you add that all together and it's kind of combustible. So and you force people to be at home for 3 months and everybody's kind of on edge. So it's a lot easier to respond to someone in a mean way or to retweet someone and advertise your outrage about it now than it was maybe 6 months ago.
Yeah.
So we definitely are seeing, I'm seeing a lot of that, a lot more. And, it's become a tough situation because a lot of people are living under the threat of cancellation. I pulled something from Tablet Magazine that says this is how we're living now under the penalty of cancellation. It's a culture of screen capping, filming, and snitching, and offense seeking and finger pointing, and it's intolerance on steroids. You can define it how you want, but it really affects a lot of people. If you have a small business that all of a sudden you're getting hundreds of posts about something that you did or did not do, it can put you out of business. It can get people to stop following you or stop using your services, and it might be based entirely on falsehoods. So, the things that we've been having to deal with is figuring out what do you do about it, how do you deal with it, and how can you remedy it, and whether there's even a legal as opposed to public relations remedy. And so again, it depends on the particular situation. If somebody posts something about you or your business that's a lie, that's defamation. If somebody is lying about something that you did as opposed to their opinion, for instance, hey, company XYZ discriminates against Black people. Okay, they post that. It may be completely false, but all of a sudden you have comment and repost and share it with other people, and you have a snowball effect that's really problematic. Now, the question is whether or not you can have a remedy for it or not, a legal remedy for it or not. Oftentimes, it's mostly a public relations type of issue. And from what I've seen, it's kind of going viral as a 36-hour cycle, and a lot of people can get through it. There's also a difference if you actually made a mistake or did something wrong, and own up to it and fess up to it and commit to doing something different going forward.
And listen, if you need PR help, you just go to Laura Richardson.
Yeah, absolutely. And in all honesty, a lot of it is PR more than legal. So call Laura, tell her what's going on, and wait the 36 hours, and hopefully she can clean up the mess for you after it. If that doesn't work, then you email me and say, I got a problem, and figure out what to do on the legal side.
There you go.
And again, there's a couple options. There's a couple legal options, and then there's reality. And let me talk about that. Like I said, if somebody is lying, if somebody posted something false, that's defamation. If somebody tells one of your clients or customers not to do business with you because of it, it could be tortious interference. But the reality is, when you're dealing with the mob, who are you going to sue? You're going to sue 400 random people who have Twitter screen names that you can't find? That's the practical reality of it. You can't go to Twitter and say, hey, take it down. It's there. You can't, maybe you can delete comments or something off your Facebook page, but the reality is it's there. And can you get any legal recourse? Yeah. I mean, if somebody defames you, you can sue them, and it'll take you 3 months to find out who they are and to serve them. And they have a couple months to respond and answer. And hopefully 3 years from now, you've got your resolution. But, when the mob comes after you, it is very difficult. It can cancel your livelihood, whether true or false. So it's a very, very difficult problem right now that a lot of people are facing, and they're in full candor, there's not a lot of solutions for it. Definitely the PR front.
I really hope that none of our participants here today have dealt with it. But if anybody has and wants to do any comments, I know that we do have you? I'll
tell you, I'm seeing a lot of it. I mean, almost weekly, people are contacting me saying, hey, the mob is coming after me. This is why. Can you help? Or, hey, I've been sued because I put a comment on Facebook, and now I just got served with a lawsuit. Can you help me?
What?
So I think that we're going to be seeing a lot more of it.
Well, I do have a question for you also. Have you heard of any opportunists targeting businesses? COVID-related frivolous lawsuits? Example, being required to wear a mask, or cancel culture defamation via social media. So sounds like just exactly what you were talking about.
Yeah, so there's a few things there. Private businesses can require you to wear a mask. Mm-hmm. You don't have to use private businesses. If you don't want to go to Publix, go to Winn-Dixie. If you don't want to go to Winn-Dixie, go to Target. If you don't want to go there, go somewhere else. But private businesses can require you to wear masks.
That was a big deal with Costco, I believe, right? People were all up in arms when Costco was requiring them to wear masks, and people were like, I'm never going back to Costco again. And
yeah. So, and those big businesses, people were complaining about it and get all their friends riled up, and we're going to boycott Costco and all those kinds of things. Those people will come out of it. Obviously, small businesses, it's a lot more difficult, but you're seeing a lot of that. In fact, yesterday I saw that Broward County, Fort Lauderdale, the government mandated masks in your homes, private residences, which for some reason has not generated the news and the outrage that I thought it would. I don't think that it's illegal, it's unconstitutional, and they're not going to be able to do that. But as part of their administrative order, I saw that the other day where it says that you're required to wear a mask at home and required to have any guests at your home. Private residences wear masks as well. So that's kind of the snowball lunacy that we're getting into. But, you know, the outrage at the government is a lot different than outrage at private citizens. But we are seeing that things that we're seeing with respect to the small businesses are, you know, I'm against this practice. I'm against what you said. I'm offended at what you said. We're not going to use you anymore. There is not much you can do about it. If it's one person who did something or the culprit, you can figure out who it is and go after them. But ultimately, what are you going to do? It might be some kid sitting on his bed using social media. How are you going to be remedied? You're going to sue them for all of your losses and try to collect from them years down the line. It's a it's a problem. And the law has not caught up to the digital age to really deal with it. We're using general defamation laws, you know, a couple hundred years old. It doesn't really protect against our technology today and mass mobilization of boycotts. Litigation is slow and painful. Whether you're going to be able to collect is a question. Paying your attorney is very expensive to get this done. And you don't necessarily get your attorney's fees back, even if you win.
Especially if it's, you're right. What if it is just a kid in his parents' house on a bed and all he has is a bed to his name?
Yeah. You go and collect the bed and sell it at a public auction. You get a piece of paper that says you won, but meantime, your business is in tatters and your employees are gone. So this is something I'm really interested in, and you know, it's a problem. It's going to be a problem until it's fixed, and I don't know how it can be fixed.
I'm going to, at the moment, just stop everyone. It is 10:58. We're going to continue on with this conversation because it is amazing, and I want to thank Ronnie. We're going to continue on. If you do have to leave, because we are very aware of the time, we do want to thank you for being here, and we will continue. Ronnie, thank you.
Yeah, so I'll go quickly. In the next section is general employment law. General employment law obviously is pre and post pandemic relevant. So some of the things to consider, especially now, is the working from home situation. What happens if somebody gets hurt from getting up from their desk and going to their fridge and they trip and fall? Is that covered by workers' comp? Are they on their own time? Is it within the scope of their employment when they tripped and fell? Another issue is clocking in and out. I have, you know, our firm, I made it optional whether to go in or not to the office. So everybody's working from home. How do you deal with keeping track of people's hours? Is it on the honor system that, hey, I'm clocking in and out at the right times? How do you know? Do I have to pay somebody overtime because they're working more than 40 hours a week? They're not coming into the office. They're not sitting at their desk. I have no idea. And, you know, it's really beneficial to develop a work from home policy now if people are working remotely. Some of the things to consider: the Fair Labor Standards Act governs minimum wage. It covers overtime lawsuits. And one of the things that's very, very difficult about that law is the prevailing plaintiff gets their attorney's fees back. You, as an employer, if you win, you do not get your fees back for paying your attorney. So you can be $50,000, $75,000, $100,000 into attorney's fees defending an employment suit, for instance, for unpaid overtime, and win, and you don't get your $75,000, $100,000 back for winning. You get a paper that says that you won and you're right, but meantime, your bank account is empty. So under the Fair Labor Standards Act, especially for overtime issues, Overtime says that an employee can own, and obviously this is general, there's exceptions and exceptions to exceptions, all those things, but generally speaking, an employee who is non-exempt can only work 40 hours a week, and anything over that needs to be compensated at time and a half. The employers that are subject to overtime under the Fair Labor Standards Act are employers that have over $500,000 in sales or business done. Or alternatively, if you don't have that much in sales, it's any business that involves interstate commerce. And interstate commerce is basically anything. If you use phones or internet or email, if you sell or distribute products that are from other states, all of that is interstate commerce. If you use the mails regularly, that's interstate commerce. So essentially, everybody has to be careful with the Fair Labor Standards Act. Exempt, and there's a bunch of exceptions as to who's not covered. Generally speaking, employees that make over 568 a year who are on salary are exempt. Also, there's executive, professional, and administrative duties that if the employee is covering those duties, for instance, if they're supervising 2 or more other employees, if their primary duties are management, HR, and have genuine input into hiring or firing other employees, they're generally considered exempt, as are learned professions like lawyers and doctors, high-level jobs that keep the business going and operating are typically exempt from overtime. But those that are non-exempt, 40 hours is the max. Anything over 40 hours has to be paid time and a half. You can't average time over a couple weeks. The 40 hours in consideration of whether you have to pay the time and a half of overtime has to be in a 7-day period. There's an obligation to keep records. And, you know, one of the things that has become an issue, like I said earlier, in COVID is people working from home and determining how are people keeping their time, whether they're doing it accurately. For instance, you have a very, very good, eager employee who is on the ball, emails, responds on time, and, you know, they wake up at 2 o'clock in the morning and they respond to a couple emails. That's working. As long as they're doing any work for an employer, that's on the clock working. And they can, even if your employment policy or directive is that anybody who works overtime without permission, it's impermissible, it's not allowed, you'll be fired if you work overtime without permission. If they do it, they're entitled to it. That's the law. So, you know, the overeager employee is you need to have special consideration for that now, especially if they're working from home, because if they're doing work, they need to be compensated for it. And, you know, it's hard to keep those records, if not impossible. Oftentimes it's their word against yours. And like I said on the last slide, the prevailing plaintiff gets attorney's fees. So if there's a dispute and you get sued for overtime, even if you're right, it costs you. I found overtime suits to be one of the most difficult and unfair laws around. There's good motive behind it. People deserve to get compensated for their work, but it is very, very strenuous on an employer because you can't prevent somebody, you can't handcuff somebody and tell them not to do work because you'll owe it. And if you fight it, it's expensive. There's a big incentive to settle those suits right away at the outset, even if it costs more than you think it needs to be. The other things to worry about are Title VII, Civil Rights Act, and the FCRA is the Florida Civil Rights Act. Title VII is the federal law. Florida Civil Rights Act is the state companion, and it prohibits discrimination, retaliation on the basis of race, color, sex, religion, national origin. And most recently, about 2 weeks ago, the United States Supreme Court interpreted the law to protect against discrimination based on gender identity and sexual orientation. So for, the law came about in the late 60s until 2 weeks ago, it did not cover transgender discrimination, retaliation, or homosexual, lesbian discrimination. Up until 2 weeks ago, you were entitled to discriminate and retaliate against people for that. And it was determined and held 2 weeks ago that it does cover them. So I think that we're going to see a significant uptick in Title VII and Florida civil rights cases based upon gender identity and sexual orientation, discrimination, and retaliation.
I was actually curious about that because of the change. Do you think a lot of it will happen because of what had happened in the past prior to that getting changed a couple weeks ago?
Do I think it was because?
No, do you think that the lawsuits will come up from what was priorly done before 2 weeks ago, or just recently?
I don't know if the federal law allows you to relate back to events that happened before the judicial decision, because clearly before this judicial decision 2 weeks ago, those were not covered. Mm-hmm. You would get your case dismissed if you filed and said, I'm gay and I was discriminated against. A court would have dismissed that case. So I don't know if it would relate back to it.
What do you think the new cases would be involved? What type of new cases do you see kind of?
It's just like gender discrimination, religious discrimination. You're going to see people who are going to say, hey, I was transferred and I got worse work assignments, or I got transferred to a different location because I was gay. My manager wouldn't work with me because I was transgender and I got moved to a different department and I'm making less money. So it opens up the door to all those types of claims of discrimination, retaliation. Somebody who goes and complains to the HR department that their manager is discriminating to them because they're gay, or they get terminated and they think it was because of that. Those are all going to be viable claims now when they weren't before. And this applies to companies with 15 or more employees. A lot of people don't know that these civil rights, especially Title VII, applies only to companies with 15 or more employees. So if you have 2 or 3 employees, it doesn't really, this law doesn't cover it. It applies both to private and public sectors. It prohibits discrimination in hiring, in promotion, in termination, and retaliation if somebody's complaining about it. And it also covers hostile work environment for those issues. And the way that someone goes about bringing a claim is they say, hey, I was discriminated because, for instance, I wasn't promoted, and I think it's because of the fact that I'm a male. And the employee would have to make a prima facie case. They would have to say that it was because of my protected status, my sex, my opportunities of employment were taken away from me because of that. And it was caused simply because of my sex. The employer then gets to say that there was legitimate non-discriminatory reasons for the actions. And then if they do that, the employee gets to say, well, those non-discriminatory reasons are just pretext. Mm-hmm. So that's kind of the framework for how it is. It's a plaintiff brings the case, says that they were discriminated or retaliated against. Here's why. The employer can say, no, that's not the reason. It was really because you weren't profitable. Right. The employee then comes back and says, well, that's not really true. I was profitable. And oh, by the way, you made all these statements about my gender 3 minutes before you fired me. Yeah. So that's how that law works. Again, the prevailing plaintiff would get their attorney's fees. The employer does not. There's all kinds of time deadlines for filing with the Equal Employment Opportunity Commission or the State Human Rights Commission. those government entities get an opportunity to review the matter first, and they can actually file suit against the employer if there's something egregious going on. If not, they give the employee a right to sue letter, and then the employee can sue the employer. There's different damage caps based on employer size under the federal Title VII, but employees would be entitled to back pay, which is all amounts that they would have received if they were working up until the time of trial. Front pay, which could be a duration for a couple of years beyond a trial. Compensatory damages such as emotional distress, doctor's bills, things like that, and attorney's fees. So that is a very high level overview of employment law. Employment law has many different factors: minimum wage, overtime. Each of them can last a day in and of themselves, but those are kind of the high points, highlights to consider.
I do have, and thank you so much. This is so informative. I can't even tell you. I greatly appreciate it. But I have in a lot of my commercial bankers and commercial real estate people ask this question quite often whenever they can. So I have to ask it for them. Are you predicting that in the area of real estate law, there's been such a lot of foreclosures happening? This whole work at home has really taken over, steering away from office spaces. Everybody's kind of just gearing towards a different direction. How do you think those trends will actually really affect the real estate market and the long-term effects of it? Because I know that they're all thinking like, what is going to happen? Like,
right.
What is going to happen? What are your thoughts on that?
Our firm actually specializes. I probably have 20 people who do foreclosure type work on behalf of banks and servicers. So this is something that I've been monitoring from the second that I heard about it. I think obviously, these are predictions. I don't know for sure, but I think real estate is going to plummet in 2021. I think that commercial landlords are going to be in a very, very tough spot. Not only are people realizing that they can work from home remotely without much loss in productivity, businesses are learning that they can have remote employees without having to pay exorbitant rents. It's not there's no all clear for people to go back to buildings yet. In New York City, I mean, people can't take elevators together, and all those high rises are empty. Here in, that would be relevant in downtown Orlando or Miami, something like that. But I have a feeling that commercial real estate is going to significantly fall. I think that you're going to see tremendous foreclosure volume on the residential side come 2021. One thing you got to keep in mind is Florida's governor has issued executive orders prohibiting evictions and foreclosures right now. Mm-hmm. So for the last 3 months, the law has been that even if you file a foreclosure suit or an eviction suit, the courts will not hear it. There's a lot of people not paying rent. A lot of people not paying their mortgages right now. Some of that from the banks or the landlords deferring it, but at some point in time, that is going to come due very soon. And a lot of people are expecting full payment for the last 3 months immediately. And when they don't get it, they're going to file foreclosures and evictions. And we don't know how that's going to shake out yet. The last 2 months, Florida's governor has executed an extension of the moratoriums the day before they were going to run out. So, June 30th, the governor signed an extension for all of July, and we've got to wait and see what happens. Now, this past week, Florida's governor announced that he has $750 million in federal aid that's going to help people with mortgage assistance. How that's divvied out, I don't know. How far that goes throughout the state, I don't know. So they're doing things, but the reality is there's a lot of private companies, private individuals who are owed money who are not going to be able to make their own payments to banks or what have you. And so they're going to have to try to foreclose or evict people. And I predict the second half of this year, the first half of 2021 is going to be really nasty on the real estate side.
That's, I mean, you have to think about with less people having jobs, and then is there going to be concern about our homeless population?
Yeah, you're gonna have. I've told everybody that we have not felt the effects of COVID yet on the real economy, because the government has pumped stimulus into the system, whether it's to the banks, whether it's to, the stimulus checks to individuals. People, there's been a false prop up of the economy, which is fantastic for the short term.
Right.
And it has allowed these things to kind of be prolonged a little bit. But at some point, the bill is going to be due, and people are going to be wanting to collect, wanting to foreclose, wanting to evict. And I think the volume is going to be heavy, unfortunately. And that's why I say I don't think we've felt the effects yet. But every day you're seeing companies go out of business, people become unemployed. They all have bills to pay.
Yeah.
So I don't think we're there yet. And I don't think we will be there until after the election. We got to remember that, our system is one where people vote and optics are important. And I don't think politicians on either side really want to start evicting people and foreclosing on people, because just the optics are bad. And so I think it's going to be after the election. So November, December, January, and then you have the holidays that may be an issue too. So that's why I think come January 2021, it's not going to be pretty.
Well, I wish I didn't end on that note.
Yeah, that's reality, and I think people are doing what they can, but I think there's some tough days ahead.
You did an absolutely terrific job, Ronnie. Thank you so much.
Thanks for having me.
I can't wait to get those slides. Also, if we could get that presentation so that we could put it up next to when we get this video up. And if anybody else has any questions, you can direct them to business@oviedo-wintersprings.org, and we'll make sure that they get to Ronnie. And Ronnie, also your phone number is there. And yeah, you got your information right there. www.bitman-law.com. And Ronnie, again, thank you so much. You have a wonderful day. Everyone have a wonderful day, and we hope to see you soon.
Thanks a lot. I appreciate it.
Thank you, everyone.